Now, on the issue of democratic theory and constitutional purpose, I want to know from you, do constitutional term limits serve primarily to prevent individual power concentration or to ensure democratic competition, in your view?
Mr. Chairman, I don't understand.
I'll repeat.
The question. Yeah.
I'm saying that I'm now delving into area of democratic theory and constitutional purpose. And my question is, in your view, does constitutional term limits serve primarily to prevent individual power concentration, or it is there as a constitutional imperative to ensure democratic competition?
Can you give me some examples, please?
Yes. The example is that, for instance, in Ghana, there's a constitutional term limit that, okay, for the presidency, your term, 4 years, you can go again. And you earlier answered it when you said somebody was trying to, my colleague John Dakun was suggesting to you that, does that mean consecutive terms? And you said, the Constitution says 2 terms, and that's it. Of course, we've had Professor Kwesi Prempeh, the chair of the Constitutional Review Committee, being very clear that 2 terms means 2 terms. Now, with that background in mind, what I'm asking you to share a view on is whether or not this provision is there to primarily prevent individual power concentration, or is there to ensure democratic competition? Is it clear now?
It's clear. Mr. Chairman, what the Constitution says is the law. Whatever you say beyond the Constitution is noise. And no matter the many noises you make, the law is what? It's the law. You can't read any meaning into it apart from what the law says, Mr. Chairman. It says 2 terms. And whenever the Constitution gives a term limit, you have to follow it, Mr. Chairman. Unless it's amended or repealed, you don't have a choice. There's no other interpretation you can give to it than what it is, Mr. Chairman.
My Lord, you have earlier expressed a view on interpretation methodology. And you ran us through the various issues to consider. And I think I heard Honorable Ayariga commending the view expressed and invited the students to pay attention to that. Having given that view, and I would want to ask you this. Ghana, which sometimes can have politically sensitive cases, should the Supreme Court err towards restricting or expanding executive power when text permits multiple interpretations? And if so, what factors will guide that?
Mr. Chairman, I've said this several times with all respect, that what the Constitution says is what should be done. I don't know what more to add, sir. If the Constitution says 2 terms, I don't see how a different interpretation can be put to it. Mr. Chairman, I don't know what, that's what I think, sir.
My Lord, your colleagues who came before you, especially during Kufuor's era, had cause to give a certain interpretation to the Constitution. And just for our purpose, I remember that in looking at the law, they suggested, they made a strong point in their judgment to the fact that once the president is out of the jurisdiction, there must be someone in the jurisdiction to act, and the person must take the judicial oath. Now, it's been long. This ruling or judgment has been in our books for so long a time. It's like what we previously, as lawyers, were adhering to, that when an injunction application is filed, though it has not been determined, once you've been served, you must not do anything to disturb it. And we're going on with this for a long time, till recently in the Coasifwa 3-2 decision, my Lord Kulendi, writing the majority opinion, said no, there must be express order from the courts. That is now the new law without any ambiguity, and says that constitutional bodies must be allowed to do their work and all. The nation has heard you, the court, on this, and we would abide. Now, having given you this sufficient background as to precedent, may I know from you whether, in view of technological impacts on the practice, and you've talked about AI this morning, on repeated occasions, in view of technological impact, having regard to Article 68, would there be a requirement for the Speaker to take presidential oath when acting in the absence of the President and the Vice President?
Mr. Chairman, if the law says he needs to take an oath, he has to take it. If it doesn't say so, then he doesn't take it. Thank you.
But does the law say so? The Constitution says so, that he must take an oath when acting as president. Take the presidential oath. Does the Constitution say so?
Yes.
Lord may guide us with the particular exact provision, please.
If you see, I think it's article. Well, I can't get it offhand, but Mr. Chairman,
we can look at it. You can take your time and provide that later. But you can furnish us with that later. But my Lord, my question directly related to this is that in an era of instant global communication, does this distinction remain constitutionally necessary? And should, quote, absence from the Republic, unquote, be redefined, in your view?
Mr. Chairman, with technology now, absence, it has a different meaning now, because a case came before me as to the meaning of working from home, as to whether during the COVID time, working from home, whether it's from your house or from outside the workplace. I think if the president, this is my opinion, please, if the president should be out of the country, let's say for 1 day, and coming back, yes, the Constitution says there should be no vacuum. But if the person if the technology can make you work from outside your office, but well, the law says if you are out of the jurisdiction, fine. But if you are in contact with those who you work with, I don't really think, and the period is that short, maybe 1 day, I don't think there should be this ceremony when you are coming back the following day for somebody to swear an oath. And then the following morning, the president or whoever's oath is taken is back.
Is my law departing from the law? Is the law?
The law is the law, but I'm not departing from it. But what I'm saying, this is my personal position. Mr. Chairman, what I'm saying is that, let's say the president goes to Nigeria and will come back in the evening. He's not in the country, but that does not necessarily mean that the vice should take an oath to act for him when he's coming back in the evening. I mean,
so, my Lord, Lord, so you yourself, you are very dynamic in your views, because you see, earlier, your view of the law, when we were talking about some other provisions, you were like, the law is a law, which is true. Yep. But again, you have now qualified it, giving it a purposive interpretation to meet the times by saying that, yes, if the person is going out for just 24 hours, would there be the need to have that ceremony of having to take the oath and all? So, therefore, you would agree with me that eliminating the speaker's oath requirement in such circumstances would be prudent, correct?
No, Mr. Chairman, what I said was my opinion. That was my opinion.
You are here to express an opinion.
Yes, may not necessarily be the law. If the law insists that...
My Lord, it's your opinion that becomes a law. At the Supreme Court, it's policy decisions.
But it doesn't override the Constitution, sir.
Well, my Lord, we would reserve that debate for another word. But
all right, thank you.
I will come back to you. Let the
you.
chairman intervene, and we'll go back to it.
Honourable members will listen to my Lord very well. He indicated that the law is a law. The thought-provoking issue that he is stating is that if the president is traveled to Nigeria and will come back the same day or the following day, both the president and the vice president are not there, do we have to do the ceremony by way of swearing in the speaker, only for him to return after the swearing in to come and take his position? So these are issues that we can look at. So he still believes that the law is the law.
So, well, Lord, I think the jury is out there to have their own bite, so I will not belabor. Now, there is clarity to me on the issue of, in the absence of the president, the vice president acts. There is also clarity to me on the issue of, in the absence of the vice president, the speaker acts. But what is not clear to me is the earlier position regarding, the earlier position you took regarding the Chief Justice, that in the absence of the speaker, the Chief Justice would have to act and take the presidential oath. Now, my Lord, is this position you took earlier in response to a colleague's question emanating from the Constitution expressly, that in the absence of the speaker, the Chief Justice takes the oath of office as acting president? Is there such express constitutional provision? Or you are just, you stating so as a matter of course, that there should be no power vacuum? Because obviously, like it happened recently, it may happen again, where the president was out, my Excellency, Madam Vice President was on sick leave, and then Mr. Speaker was also out on official assignment, and for 48 hours, there was no head of state, technically, in the jurisdiction.
Mr. Chairman, I was answering a question asked by an honorable member as to the hierarchy. If the law says that for somebody to act, as the president of the country, he must take an oath. That person has to take the oath.
My Lord, take it easy.
No, I'm fine.
No,
I'm
no,
fine.
you step by step.
I'm fine.
I mean, it's a good exercise that we have to embark on. If there is a lacuna in the Constitution, we must recognize it as a nation, and I believe the Constitutional Review Committee is following proceedings here. Now, my first question, and I will take it step by step. Is there an express constitutional provision that requires the Chief Justice to take the presidential oath in the absence of the President, the Vice President, and the Speaker of Parliament? Is there an express constitutional provision?
Mr. Chairman, on top of my mind, I can't give any now. But if I'm given the chance, maybe I'll go through and see whether the Oaths Act or, I don't know, says so, or I don't know.
So let's do a little exercise. Granted, there is no such express provision. In your view, as a judge, and my Lord, it is your opinion that will add up to other views once you get to the bench. That court is a constitutional court. And if I may recall, I once did a case at the Supreme Court where, after losing the case, one of the panel members passed a comment that here we take policy decisions and look at the broader, affairs of the state. Just to assure me that don't be too heartbroken that you've lost this case. And it was a very sensitive matter that had to do with some freezing and of account and the state utilizing some exhibit account. And later I appreciated the position of the court that if all those monies that had been used by the state as exhibit account were to be said that go for your money, it would have been something else. So that is the background to the point I'm making. Now let's come back to the issue. In the event that the Constitution does not make an express provision for the Chief Justice to act in the absence of the Speaker, the Vice President, the President, who, in your opinion, should act as President?
You mean if the Vice is not in?
Let me take it back.
Yes.
The President is not in the country. The Vice is not in. The Speaker who took the presidential oath has also traveled. Who is the next to take?
Mr. Chairman.
Is there an express provision?
You see, there shouldn't be a lacuna. At every point in time, somebody must head this nation. The three are not in the country. The next person is the Chief Justice. The next person, as we all know, is the Chief Justice. Even if there's no express provision stating that, there shouldn't be a lacuna, there shouldn't be a vacuum. And what I was saying, Mr. Chairman, is that if the president is just away, or those who are just away, or one of the three is just away for within a day, he will go and come back. There is no need for that exercise, because the person is coming back the same day. I don't know. Mr. Chairman, I think...
My Lord, if you look at Article 60, if we run through Article 60, all through to 12, my Lord, I do not see any express provision. I've read, I'm still a student. My reading can never be accurate. I've read 60, the entire 60. There is no express provision for the Chief Justice to act in the absence of the Speaker. And my Lord, I am laboring on this point because recently it happened where Mr. President was out, VIP was not in town, Speaker himself was also out of town on official duties. And, so I just want to know from you, you are now going to the bench. What is your view? I hope there's clarity now. Thank you very much.
It's clear. I think there's a lacuna there. So it has to be filled up. There shouldn't be that vacuum. So I think the Supreme Court that has the power to interpret can come out to say that, to make it definite that when those three people are not there, this person takes over. And this is
Which
what
person? This person, Mr. Speaker, my Lord, this person.
When the president is not there, the vice takes over.
Yes.
When the vice is not there, it's the speaker. And if the speaker is not there, I think there should be some express provision to say that there shouldn't be a vacuum.
So tell me your opinion. In your view,
my opinion,
who should be the next?
My opinion, the next should be the Chief Justice.
Very well.
That is my personal opinion.
I agree. No, Lord, it's fair. Yeah. It's the personal opinions that become the law to guide us. I agree. Thank you very much. My Lord, I want us to deal with emergency powers, emergency succession protocols. Now, constitutional succession framework designed for unprecedented circumstances. In your view, should temporary successors beyond the vice president have full executive powers? And what constitutional limitations, in your view, should apply? Because they've taken an oath. They've taken the presidential oath.
Yeah, Mr. Chairman, yes, they've taken the presidential oath, but I don't think they can exercise all powers in the absence of the president. There must be a limit. For example, if the president should travel, the vice travels, and then the speaker takes an oath to act, and he decides to change ministers, appoint new ministers in the absence, it's not the best. So I think, yes, to avoid a vacuum, yes, somebody must lead, but certain decisions cannot be taken by that person. I think so.
But the person has taken a presidential oath.
Yes.
Now, how would you balance governmental continuity with democratic accountability in extended succession scenarios?
I don't understand, please.
So we've talked about succession. They could be temporal. But we can have situations where the time could prolong. And in your view this afternoon, you have also said that, look, those powers must have limitations. For instance, the person acting should not have the power to fire or even appoint ministers. I've heard you. Now, I'm saying that in view of that, how do you balance this governmental continuity, which is allowing somebody to act, and the requirement of accountability?
Mr. Chairman, the state must run in the absence of those people, as we said earlier. Yes, we have to balance it. The state must not come to a standstill. But then you must know the kind of decisions to take in the absence of the substantive people. That's what I think, sir. The state must run.
My Lord. in your view, what are the specific constitutional amendments you recommend to modernize Ghana's political succession framework?
Can you please clarify the question for me?
Well, I'm rooting it on the earlier foundation that I laid, the temporal succession, who is taking over and all that, in the absence of this, that, and you've already expressed some broader views. Okay, so I now would want to hear your views regarding some recommendations, because you've talked about some limitations. I just need you, in view of that, to make certain proposed recommendations by way of constitutional review. Because you agree with me that even the inclusion of the Chief Justice in the succession plan is now coming by way of a purposive approach to governance, that you don't have to leave it vacant, vacuum. There shouldn't be vacuum. But there's no express provision. So share with us what you see as some recommendations to guide this whole process, because it's very critical in view of the experience we've just had.
Mr. Chairman, I think this is for Parliament to do. You have to pass laws as to what should be done in those circumstances. I beg, sir.
My Lord, so you mean we should enact a law to regulate Article 60 further, but we can't enact where...
Or further, maybe when that issue comes before the Supreme Court, through the interpretation, the decision they will give, then they will clarify and give further instructions as to what should be done in those circumstances.
My Lord, you remember Article 1815, the Clomega? The Supreme Court left that bit to Parliament, and it is still hanging, where they said Parliament should enact to regulate 1815. It's in the light of this that I want to ask you whether in such circumstances, in view of the amendment we're looking at, Supreme Court, in taking this up, would look at it holistically and provide a guide without saying Parliament should do this bit, because this is very constitutional, in my view. What do you think?
The duty of the Supreme Court, when it comes to interpretation, is the Supreme Court. So these are very good points you are raising. I think the Supreme Court, when the matter comes before them, will have to sort it out and give the various guidelines as to what should be done in the circumstances, Mr. Chairman. I think it's a gray area. So when it gets to the Supreme Court, then they will define it and give further guidelines as to what should be done. Thank you, sir.
My Lord, the records have it that you've been at the Court of Appeal since 2010, correct? Or more?
2010.
Since 2010?
2010.
Okay. And you presided over that committee, that football committee. What's the name of that committee? There was a commission of inquiry or committee.
Mr. Chairman, you know that commission's name. Dzamefe Commission, the commission. It's not a committee, sir, it's a commission.
Yes.
Thank you, sir.
Lord, when I forget, assist me.
Thank you.
Lord, so in that commission that you chaired, what did you really unearth by way of the whole hearing? And do you think that the recommendations that came there too has been implemented to guide football administration in our country?
Mr. Chairman, some were, but not all. We recommended a lot of recommendations, but not all were taken. But I can give some that we did, and we said, one, players should not be paid cash. We all saw what happened in Brazil when we had to fly money to Brazil for players, and we saw some people holding theirs. It was one bad thing for Ghana. Then number two, we also recommended that the state should not sponsor supporters to go to countries, to fly them to countries where we are playing. Instead,
That one is still happening.
well, I have done my job. Because we were thinking that instead of flying people from Ghana and booking hotels and feeding them, why don't we buy tickets for Ghanaians who are in that country? Then again, we also recommended that every time the Black Star plays, at least 3 local players should be in the team for continuity, 3 local players. And you all saw the House of Oak goalkeeper, the local player who did very well in the post, conceding those goals. These are some of the recommendations we made. And then that we also recommended that the state, the parliament should know all matches to be played in the year ahead of time. I think sometimes the organizers wait when it's a week or 2 days to the match, then they bring their budget and you are forced. The only event in the world you cannot change is FIFA events. If FIFA fixes a match, you can never change it. You are forced to find money. So we recommended that matches should be, the state should know far ahead of time so that they can prepare towards those matches, not to wait till 2 days and then they bring you a budget. You have to, by all means, find money and send the players. These are some of the recommendations we made.
My Lord, this is a good point to ask my very last question to end the day.
Thank you very much.
To end the day with you. My Lord, you dealt with criminal cases for many years at the High Court. It came to a point in our criminal jurisprudence where lawyers and judges came to a certain conclusion that there was this non-bailable offenses, until the same Supreme Court now came with a groundbreaking or a landmark decision that bail cannot be used as punishment, and certain parameters were created. Now, that is court bail. What I want us to do to conclude the day is inquiry bail at the administrative level, where a state institution investigating a person and is unable to complete investigations and is not ready for court would grant bail on certain terms. Now, for all your years as a judge, would you suggest, would you say that an institution like IOCO, OSP, or the police service itself should arrogate to itself the power to demand what has become known as justification as bail condition, especially when they are not even ready to come to court? My Lord, I'll give you a bit background to it. In the public space, what we have heard through public statement issued, Chair, I just want to give my Lord enough background to it. I mean, ordinarily I'll go straight, but because the exercise is very good for our country, so that he can appreciate it. My Lord.
But my brother, you know the rules, that when you are given the opportunity to ask questions, our rules does not allow you to address. The rules does not allow you to share your opinion or argue. That is why I am just reminding you of our rules, that you are to ask questions.
Okay. Chairman, that's okay. Thank you. I'm guided. So, honorable nominee, I am giving you this background in view of the fact that in recent times, Iyoko specifically, they have justified their action of requiring landed property titled, registered with the Lands Commission with valuation report as the basis for their bail condition because of the amount they are investigating. Because of the amount they are investigating. As a judge, don't you think that these considerations matters for the court to determine? And that to the extent that the investigative body, like Iyoko, is not done with its investigation to bring the person to court, demanding landed property as a condition for bail merely because there is an investigation to that amount would be a bit onerous.
Mr. Chairman, from my experience, when we are faced with granting bail, we look at the charge, the amount involved, if it's liquidated, if it's money, the amount involved, and weigh the pros and cons as to whether the person will consider not coming to court for trial, whether the person is a flight risk, and we consider all that. You can't be, the basis of bail is to make sure that the person comes to face trial. But then, you can't be investigating a case, let's say, for example, $1 million in a theft case or something, and grant bail 10,000 cedis. There's a possibility that you are indirectly telling the person, go away. So we consider all these things. But I cannot tell what informed that decision by Iyoko. No, I cannot tell. I cannot tell. It's not yet at the court level. So I can't tell why they demanded that. I cannot fault them for that.
My Lord, I'm not saying fault them. Yeah, my Lord, I'm not saying fault them. My Lord, I'm not saying fault them. On the issue of courts, I have no problem. Because you, the presiding judge, will now look at the charge sheets, the evidence available, and in fact, in our modern criminal trial system, you even make available all your documents you are relying on as part of the discoveries, contrary to the previous practice where you keep it under your armpit and be releasing them one by one. Now, from day one, you are to give every document to your adversary or to the accused. I am concerned about the use of such powers at the investigation level, where you have not even concluded, but you know that the amount you are investigating is X. It could be right or wrong. It could be true or not. You've not gone to court yet. That is where I want you to share a view on for us. Not to blame Iyoko. That's not what I'm asking you to do. We are expressing a view to enrich democracy.
Mr. Chairman, at the investigative level, they are not saying you are guilty or not guilty. Granting bail and putting a figure on it is just to make sure you are available. And Mr. Chairman, don't forget that when you get to court, there's the possibility of the court varying even your bail bond, lower or even higher. So it's just a means of making sure that you attend, so you report yourself for the investigation. That's all. That's all about it, sir.
Yeah, thank you very much, my Lord. We have come to an end of the vetting. Permit me to recognize our revered justices of the Supreme Court seated behind you. Then I will come to the family members. First on the list is His Lordship, Justice Paul Bafoboni, Acting Chief Justice. You are welcome. His Lordship Justice Isifu Imoro Tanko Amadu, Justice of the Supreme Court. His Lordship Justice Henry Anthony Kofi, Justice of the Supreme Court and President of Association of Magistrates and Judges of Ghana. His Lordship Justice Richard Ajay Frimpong, Justice of the Supreme Court of Ghana. May I, on behalf of the committee, welcome my lords in our midst. I then proceed to acknowledge the presence of Mrs. Antoinette Dzamefe, the wife of the nominee, Mr. William Krakani, Dr. Kofi Dako Anoche, Togbi Honuafe, Chief Honufe, Chief of Lume, Togbi